Well, thank you very much indeed, Matthew. Thank you so much for inviting me back to the modest surroundings of the RSA again. It's a pleasure to be here. It's a particular pleasure to speak ahead of Louise Casey's first major speech as Victims Commissioner. Nobody could be more delighted that Louise is speaking up for victims than I. I am an unalloyed fan of Louise and her work and the efforts which she has made over the last few years to raise effectiveness in how we tackle antisocial behavior and crime in this country. And it is a particular pleasure for me now to see Louise speaking, as she was this morning on the media, so persuasively and directly about the challenge which we all face, not just the government, which we all face in ensuring that victims have a proper voice in the criminal justice system. What I think we need to avoid is the kind of homilistic approach that we have seen, I feel, a little too often, which talks about putting victims at the heart of the criminal justice system, and yet then is so inadequate in doing so. I said in my speech to Policy Exchange a few weeks ago, when I set out the government's ambition in relation to criminal justice reform across the piece, that there are, in my view, this was in answer to a question, two groups of people. People tend to fall into one or other groups. There are those that understand the importance of recognizing the concerns and views and interests of victims in the criminal justice system, and there are those that do not. And in the group amongst those that do not are some who disparage the interests of victims and indeed stand in the way of measures which will give them a greater voice. I am emphatically in the former camp. I said in that speech that the public expect three quite straightforward things from the criminal justice system. And victims expect these things. They want the police to be there for them. They want action to be taken when crime is committed, including the antisocial behavior, which is too often ignored. And they want criminals to face the consequences for the crimes they commit. And we can't accept a criminal justice system which does not make offenders face up to consequences. And Louise's voice over the past few months and more recently in drawing attention to weak community disposals, unpaid fines, unpaid community orders, is important in understanding that offending should always have consequences. I've had the advantage of seeing what Louise is going to say already, and if I may, I'm just going to pick up on one point that she makes, which is that actually 80% of victims say they don't want any further help from the system. And that should drive us, I think, to two conclusions. The first is that we must concentrate resources that we know are going to be scarce, on supporting those victims who are most in need and do need help. And we know that they are there, and sometimes they need a lot of help. But secondly, I think we must reflect on what it is that most people and most victims do want from the criminal justice system if it is not further direct help. And it is that offending should have consequences and that justice should be done. And therefore, driving our agenda of ensuring greater accountability in the criminal justice system, driving a program of radical reform across the system, which recognizes that resources are going to be tight and therefore is far more rigorous in our approach to reform in relation to police reform and prisons reform, introducing policies like payment by results to ensure that offending does have consequences and that we reduce reoffending, mending each broken link in the chain of justice. This is important, not just for the better performance of the system, but for victims too. I am looking forward immensely to hearing what Louise has to say. And I said today in the House of Commons that the government will reflect carefully on her injunctions as we review now the whole system that supports victims, as we have said that we will, with a real determination to ensure that we never forget victims as we work in the criminal justice system. Thank you.
Thank you very much, Nick. That's a very, very kind introduction. And Matthew, thanks very much to the RSA for hosting us all here this evening. I have to confess, ladies and gentlemen, to an unusual but very high degree of nerves as I stand before you this evening. So I hope that you will forgive me if I stumble as I go through my speech, but I've thought about what I want to say to everybody tonight quite carefully. And I hope that I get through it without too many stammerings or anything else. That was actually the only humour in an entirely... That one always works. I can't help myself, can I? No. Okay. Well, good evening, first of all, and thanks very much to everybody that's made it here tonight on what is a very warm evening to hear me talk about my first impressions on the treatment of witnesses and victims after what is only actually 9 weeks in the job. It is an absolute privilege to have been appointed as the first Commissioner for Victims and Witnesses. Yes, indeed, it's a huge privilege, but it's also a hugely daunting task, and one which makes me feel very humbled, particularly when I speak to the brave and courageous people who I am now tasked to represent, some of whom are in the room today. And before I begin, I would also like to pay tribute to the many volunteers and staff who are working to support victims of crime, whether or not those victims are currently in the criminal justice system. I'd like to thank the very, very many people, victims themselves, families, volunteers, probation officers, barristers, judges, police officers, crown prosecutors. You say, I have also been up terribly early today, so this could be rocky around the edges. The victim support staff and organisation have been so incredibly helpful to me in these last few weeks, and other victims groups who have given up the time to offer me their views and their experiences of the world of victims and witnesses and the criminal justice system. And I intend to make it a very key part of my job to go on listening so I can be an informed and an effective voice for victims and witnesses. This is not the end, this is the beginning. And I want to put on record one of the things I found most striking. Every person I have spoken to did understand the importance of victims and witnesses and indeed their status within our justice system. But every person I also spoke to agreed that, that despite the significant progress made in recent years, we're simply not getting it right. So I wanted to start really by just taking a step back. It could partly be because we're at the RSA. All of us suffer knocks in life, simple as. Most people indeed in this room, if you think about it at some stage, will have suffered knocks in life. All sorts of things can set us back. And being a victim of crime for most of us is actually just one of those knocks. It doesn't define us as human beings. And most of the time, we can rely on family, we can rely on friends, we can rely on neighbours, and indeed the community around us to help us through it. Most of the time, that works, and that is the right response as a society and as a community. So I don't think we need to start from the point where we're trying to fix something that doesn't actually need any repair. It's not for government, in my view, to be providing a service for everyone and anyone who experiences a knock in life. We shouldn't and we mustn't encourage a sense of victimhood. Over 80% of crime victims themselves say they do not want help, and among those that do, what they largely want is information about their case. So that's one part of what is happening in the world of victims of crime. But for others, for victims of rape or the bereaved family of someone who's been murdered or a very nasty assault, that crime can become a life-changing tragedy that we shouldn't and don't expect people to overcome easily, at least not without the kind of help and support that actually shows a real understanding of the impact of what that crime can have, and indeed, I think, a greater recognition and understanding of their situation as victims. So there are inherent tensions here between, I think, how we think about victims of crime. We don't want to turn everyone into a victim, but we must not and cannot afford to miss those that may be vulnerable and need help no matter what has happened to them crime-wise, nor indeed those that suffer the life-changing tragedies who we should not expect to pick themselves up and get on with life easily. And there are hard-headed reasons for supporting victims as citizens and indeed as taxpayers. Firstly, as a civilized society, we do not condone or indeed allow retribution, an eye for an eye. The rule of law depends on a victim not seeking revenge themselves. So by reporting a crime to the police, the victim or the bereaved family is stepping aside, and actually the state steps in and prosecutes the suspect for an offence against the Crown. This is a very significant thing. That is the deal between the state and the citizen which underpins our justice system. And in return for the state taking responsibility, we need to repay the victims with an effective response on their behalf. Secondly, and equally fundamentally, and particularly in more serious crimes, there is a public protection imperative that I sometimes think that we forget. We know that perpetrators of violence, domestic abusers, child sex abusers don't stop at one victim. They will go on and do it again to someone else. When a victim bears witness in a courtroom, it means stopping the violent man seeking out another vulnerable woman, the sexual abuser, the violent thug, or the bully picking on another vulnerable person to go on and on to their next victim and next victim. So, of course, we should support that victim because many will find it incredibly hard to fulfill that responsibility as a witness. But society, we ask these people, we need these people to bear witness in a courtroom of law to bring offenders to justice. So in asking them to do that, it's incumbent upon us in society, and therefore the criminal justice system, to get some things right, to give them certainty or some guarantees about what they can expect, confidence perhaps that there will be protection from intimidation, that they will definitely be kept informed, and that help and practical support is easily accessible to them from start to finish. And secondly, to acknowledge that this is a crime that has happened to a somebody, to a human being, to a person, and therefore that individual will want to be involved in what happens, how it happens, will have views on it, and almost as much as any defendant has a huge interest in what happens in any trial or any proceedings. But instead of a system of guarantees, what victims and witnesses actually get is what I call a maybe system. In reality, being a victim and or a witness can still mean entering a complicated and haphazard system with absolutely no firm guarantees. When you report a crime to the police, your details may be referred to victim support. If this happens, you may receive a telephone call from victim support. You may indeed be visited by a volunteer. If your case gets as far as being charged, you will most likely be contacted by a Crown Prosecution Service or police-run witness care unit, although you may continue to be supported by a specialist police officer if the crime is very serious. The witness care unit may carry out a needs assessment to assess if you need help with attending court. They will probably put you in touch with the Victim Support Witness Service to show you around the court. You may meet the Crown Prosecution Service prosecutor if they have time, which often they don't. There may be a witness service volunteer, a court usher, a court-level witness liaison officer may also be there. If the perpetrator is sentenced for a violent or sexual crime and sent to prison for over 12 months, the witness care unit may ask if you want the probation service's victim liaison officer to keep you informed about when they are coming out of prison, which they will sometimes do. An indication of what this might mean to a witness is that they may receive up to 30 letters as they navigate this process, but equally they may never get any at all. Because what happens when a crime gets reported is that actually an administrative process is kicked off, which starts the cogs running, and then the wheels of the system of justice start to turn. And at that stage, the system takes over, the professionals step in, the police, the prosecutors, the courts, the judges, the probation deal with the offence and the offender. If you go to court, you cease to be the victim of crime, but a witness in the proceedings which unfold. I think we think of a witness as some kind of bystander in the street who saw an incident, but 4 in 10 witnesses in court are the actual victims of crime. The woman who's been raped, the householder whose home was burgled, the young man beaten up on his way home, or indeed the child that has been abused. The solicitor and barrister who prosecute the defendant are, as we all know in this room, acting for the Crown. So the victim will not be instructing them. They will not have an advocate to get across their experience. They will not see a defendant's statement in advance. They will not get to see the proceedings because it could prejudice their evidence when they come to give it. And while they may be entitled to hear about the outcome of the case, the entitlement is only to hear about it within a day of when the witness care unit hears themselves about the outcome from the court, by which time the victim may well have read about it in the paper. To that victim of crime, he or she is the reason why they are all there in that courtroom, yet the victim is the sideshow. If you are the bereaved family of a victim of murder, you could actually find yourself sitting in the public gallery along with the defendant's family, an interested student, a collection of people who perhaps have stepped in to shelter from the rain. Whereas actually what is unfolding to you is the story of the loss of your child, your husband, your wife, or your mother. So we should not be surprised that many victims and their families describe the criminal justice process as being victimized all over again. We need to be honest. At present, our criminal justice system is at root and at branch a system to process offenders and administer the law. And unfortunately, and I indeed believe unnecessarily, victims are subsumed into that administration of law. In our quest to be scrupulously fair to defendants, which we absolutely should be, and to ensure that the interests of justice are not prejudiced, all incredibly important things, it seems to me that sometimes we lose balance and we end up by being unfair and indeed inhuman on occasion to victims. Is there no limit to the number of post-mortems that can be held when someone dies and is murdered? For example, it is quite legitimate for 6 additional post-mortems to be carried out on behalf of each of the 6 defendants, leaving bereaved families sometimes months and months and months, and this is no exaggeration at all, waiting to bury their child or their father. Yet, in Northern Ireland, it seems possible, and in keeping with the interests of justice, to do any subsequent post-mortems within 2 weeks. In the interests of justice, we require all child victims of adult offenders to give their evidence in an adult court and don't allow them to sit with their family or someone they know when giving evidence via the live link. Even ushers who sit in are not allowed to reach out to the witness if they get upset. Whereas we have a youth court system, quite rightly, for child defendants, which recognises the need for children to go through a trial in surroundings that are more age appropriate. And where proceedings are undertaken in a Crown Court, there are quite a number of practice directions outlining how to make the process less intimidating for young defendants. And of course, is it right we have a system of appeals against sentence and conviction, but how is the interest of justice served when the victim hears about the perpetrator seeking leave to appeal is when they pick up the newspaper? No, ladies and gentlemen, the idea that victims are at the heart of the criminal justice system, as the Minister said, is simply not true. It is not a benign deception. There is actually nothing benign about it. I believe we can improve the position for victims without actually prejudicing the administration of justice. Let's look at allowing victims some challenge or advocacy so they can be reassured that the system is doing the very best it can in what they believe to be their case, actually. The criminal justice system overall needs to recognise much more of the deal that is done here, the victim stepping aside for the state to prosecute. So what do they get in return? An acknowledgement of interest, being kept informed, spending some time with victims to let them know how things run, perhaps even knowing what the outcome of the case is if it's a serious case on the day. What is the deal? We ask them to step aside. What do we give them in return? It's not clear to me. It's not clear to victims. We should be much more transparent and accountable. Things like the sentence that is delivered in a court is actually more or less the sentence that the person convicted would serve. Or where a defendant is acquitted in a trial, a case review involving the victim of their family could be held to go through what happened and why and what the options might be. There is often a polarised world when we're talking about crime and criminal justice. People want to create a debate that says, because you're speaking up for victims, that makes you anti-offender. I just don't think this is a zero-sum game, tempting though that is and tempting though it is to do. I am not here tonight to argue that we should instead have a system which is not fair to offenders, because I fundamentally believe that one of the worst possible things we can do in our society is to lock people up who are not guilty. Similarly, when people are convicted, what's vital is that they are rehabilitated. Don't pitch this as an anti-rehabilitation game. It's not. The one thing that victims often say is, yes, they want people punished, but they absolutely want them rehabilitated. They do not want what happened to them to happen to anyone else. What I am here to say tonight is that we need a system that is equally fair to victims, because in their own right, they are vital for justice to run its course. When we ask them to step aside and let the Crown deal with the case, this to me is as fundamental a moment as the right to a fair trial for defendants, and we should not treat them as if the victim is some kind of piece of bagged evidence in a trial process. I don't want for a moment to dismiss many of the improvements in the way that victims and witnesses are treated, and I'm sure I could have spent a lot of time tonight going through those developments. It wasn't that long ago that we hadn't even heard of an organisation called Victim Support in the scheme of things, that actually prosecutors were told they could not speak to victims or witnesses or their families, and actually nobody thought of giving victims separate waiting facilities in courtrooms. But as a sum total, these improvements just do not add up to anything that approaches real power and real challenge for victims within the system. What we have here is a David and Goliath situation. It is a defining feature of many of the organisations that support victims of crime that they rely very, very heavily on volunteers and on people who have lived through the experience of being victimised or being bereaved and want to support others who have had those similar experiences. This is an incredible, powerful and positive thing. Victims who see volunteers work tirelessly to help them know they are doing it because they care. And that when someone who is being bereaved may say something that might be challenging, it's because they actually understand and that they want to help. That's vitally important. It's the sector's strength and something as a society that we need to be very, very thankful for. But when it comes to challenging the criminal justice system to do more, or perhaps to tell them they haven't got it right, they are up against a highly professionalised and professional sector. The judiciary, the police, the Crown Prosecution Service, the Probation Service, the bar. And it strikes me that as well as these formidable professional and established groupings, there are a whole host of other organisations behind them, members' organisations, societies, trade unions, improvement agencies, management and development organisations, and of course, a significant number of offender-focused lobby groups. And the resources underline the power relationship too. Only 2% of the overall criminal justice system budget goes directly to victims. So whilst every police officer in the land, and indeed everybody in the room, can recite defendants' rights, you have the right to remain silent, the right to a phone call. We all know that language absolutely easily. Who in this room can recite victims' rights from the Victims' Code of Practice? Which member of the public can actually tell you what's in it? Even those who have been victims and who have exercised their rights, including that rather special right in the Victims' Code, which is you've got the right to the leaflet. I'm serious. They don't know about the code. We've played around the edges, some might say. We've covered our tracks about our benign deception. Or more kindly, we've introduced some very well-meaning advances. The system has created victim personal statements, the point of which is to explain how the crime affected you as a victim or the victim's family. Except, of course, it's not up to the victim or the victim's family whether actually that can be read out in a courtroom. That's for somebody else to decide. We have a code of practice that can't be enforced. We have a complaint system which is hopelessly, woefully inadequate. A system so far removed from victims that they have to apply to it through their MP, and that since 2006, that's 5 years ago, have dealt with 58 complaints in total, we've checked, of which only 2 were investigated, we checked that, and only 1 upheld. I know I shouldn't, but I can't help but compare it to the Prison and Probation Ombudsman, which last year received over 4,000 complaints from offenders. Nobody I have spoken to has suggested that the system is so good that victims have no need to complain. It's just that it's completely invisible as to how you might do it. There are major changes happening now and more coming down the line. Huge, significant cuts to budgets, major sentencing reform, planned closure of a huge amount of the court estate, to name but 3. And if we are going to do more for less, then I have no doubt that we must look at all options on efficiency, including how we use the scarce Crown Court time and move more work into magistrates' courts, if that will help. Case management, which to me means gripping a case and getting it heard on time so that a witness doesn't have to wait months on end for their case to come up. And indeed, incentives for defendants to plead guilty. It's why I've argued in my report we need to take a look again at whether a universal system for victims of crime which takes not enough account of seriousness or vulnerability of a victim is sustainable. For me, this is an opportunity, ladies and gentlemen, for radical change, and one which if we grasp and grasp it well, we can actually improve justice. That involves a reassertion of why we support victims and understanding that if we grant them some dignity and some humanity in the process, it's the interests of justice that are served. I'm conscious that in order to achieve this, there are many challenges ahead. So I wanted to say tonight, and quite publicly, I stand ready and willing to support Justice Levinson's work at the Sentencing Council. I'm ready to work with anyone, but particularly Keir at the Crown Prosecution Service, the police, Her Majesty's Court Service, so that when we talk about improving efficiency, it actually improves the service for victims and for witnesses. And of course, I'm up for and very determined to work with ministers for getting the best deal possible we can for victims and witnesses all round. Just before I finish, I want to tell you very briefly just about a couple of the incredibly dignified mothers of murdered children that I came across during my travels, both of whom today are fighting for improvements in the system and at the same time volunteering to help others in similar situations. One woman told me that after weeks and weeks of watching the man that she was told by all of us in the criminal justice system, she was told that he had murdered her daughter. When she sat for weeks watching me tried, at the end of it, he was acquitted. She was then refused a 10-minute meeting with the prosecutors to explain to her what had happened and what might happen next. The other mother I met bravely attended a parole hearing in prison, ready to come face to face with her daughter's murderer, a murderer that still hadn't revealed where the body of her child is. She was told her husband wasn't allowed to accompany her in to give her support. Those things cannot be right or just in the mind of anybody in this room or anybody in the United Kingdom today. I am seriously conscious, though, of this David and Goliath world that I inhabit and we in the victims' world live in. As much as I would like to talk up how powerful I would like to be as the Commissioner for Victims and Witnesses, and I'd like to be powerful, and I'd like to be more powerful. I like power. I actually know that I need to be a little bit clear and a little bit humble here. It is actually up to the judges. It is up to the bar. It is up to the Crown Prosecution Service. It is up to the Probation Service. It is up to victims' organisations. And it is up to the government not to close their door on me, but to do the right thing by victims of crime and recognise their role. And in that endeavour, ladies and gentlemen, tonight, on my first speech, I ask you not to close that door, but to open it wider than ever. I hope I can rely on your support and indeed your help in the months to come. Thank you very much indeed.
Thanks, Louise. That was fantastic. I think we can safely say that whatever your job title, whatever your budget, and whatever the hurdles you face, you will always be a powerful person. We've got about kind of 25 minutes for conversation, and there are a lot of people in the audience who have very direct experiences of some of the things that Nick and Louise have talked about. So I'm just going to ask one or two very short questions and ask for short, snappy responses from Nick and Louise so that we can open up and maximize the time for you to participate. I just wanted to ask this question, maybe just ask one question, which is the system you describe, both of you, is a system in which people with real pressing, almost humanitarian needs are disregarded and treated appallingly. Meanwhile, a huge resource is wasted on people who don't really need much of a service at all. Now, standing back from that, it's a bit of a scandal. I'm interested in why you think it is this has come about, because if we're going to change the system, I guess we have to understand how it is that it could come to pass that the system would be this unbalanced. Louise?
I suppose I wouldn't put it in quite such stark language, which I realise that's uncharacteristic for me, but I mean, I think the problem is that it's the maybe system, Matthew, so that it doesn't quite get it right for the people that perhaps most need it. And of course, there have been some new developments like the National Victim Service and the Homicide Service that are going to try and get it better. But that's the voluntary sector again. What about the judges not giving time? What about not allowing a victim personal statement to be read out in court, but choosing that it isn't? What about turning up to a court on the day and actually not knowing whether you're going to have to give your evidence as a rape victim behind a screen or not? Everybody says they're going to, but it's not guaranteed until the day because somebody else makes that decision. So my argument here is that we shouldn't focus too much on, and a piece of work needs to be done, I think, on do we need the type of services that we're currently offering to everybody in the way that we are? I think there's a more fundamental thing, which is do we actually reach out to the people that you describe needing almost humanitarian needs in the dignity, given the respect throughout the criminal justice system, and then indeed into parole hearings. Some of these people live with it for the rest of their life. As long as the offender is in prison and going to parole board to try and get out of prison, they don't always hear about it, even in those cases. And when they do, they have to pay their own way to get to the... there's so many failings right across the system. I think to just dwell on one bit, which is the service at the beginning, may not just be enough for me.
But there is something here that I recognise, Nick, which is that what is really needed is culture change, but what happens is a culture of box ticking. So I'm kind of interested in and I don't want to be disparaging, but, as long as people have got the leaflet, as long as people have had the phone call, yeah, then everything's been done, when actually the culture of the system is still in denial. What, as a new minister, how do you kind of perceive that problem?
Well, I think it's true that we have been more focused on wanting to achieve cultural change in some other elements of the criminal justice system than on this problem as a whole in relation to looking through the prism of victims and witnesses. And we certainly have understood in relation to policing that the key changes that are needed are cultural, and that what we need is change from bureaucratic accountability to democratic accountability, and similarly to introduce the same kinds of accountability in relation to the penal system. So I think we should be extremely wary now of responding to Louise's injunctions and the pressure to do more for victims by saying, here is an enormous checklist of things that should be done by each element of the system. What this must be about is introducing the proper accountability for making sure that these things happen in the system, getting the incentives right in the system, so that people are, as I described, they never stop thinking in the system about the interests of victims. That is a cultural change. I think the other thing to say is about resources. It is true that when resources suddenly are so much tighter than they have been in the last few years, we have seen a huge increase in resources for the whole criminal justice system. We have the most expensive, or one of the most expensive, criminal justice systems in the world. Now we don't have the resources flowing in freely, and that does require us to think much more rigorously about how well money is being spent, how well it is being targeted, whether we can use resources more effectively to focus on those that really need them, whether we have understood what the wider needs of victims are. And one of the things that I was incredibly struck by in talking to Helen Newlove when we were in opposition was that so many of the things, for instance, which witnesses want, victims, are really simple things that don't necessarily require the spending of money, but do require a will and understanding in the system to provide them, just being treated in a different way, being treated not as an accessory, but as a person whose interests are central in the system.